Presentation presented by THLA and Haynes and Boone. We have a special guest for you this morning, an expert in the area of insurance coverage. It's obviously a hot topic in our industry right now, as much as we've been hurting over the last several months. And I know a number of you have been looking at your policies, trying to navigate and figure out what types of coverage you have, what types of viable claims you may have, and ultimately recovery under your policies. My name is Brian Sullivan. I am Deputy General Counsel at Texas Hotel and Lodging Association, and I had the pleasure of moderating this webinar today for you all. And our special guest is Mr. Micah Skidmore. Micah is an attorney with Haynes and Boone. He is based out of Dallas and actually has been a friend of THLA for years. In fact, he has represented several hoteliers, including some of our own board members, throughout his tenure at the law firm there in Boone. And we have a lot of confidence in Micah. We're very excited that his firm wanted to sponsor this webinar and provide the value and content that you all are able to receive today. Just a couple of quick logistical notes as we get started. If you do have a question, as Micah proceeds through the presentation, please utilize the question and answer there in your Zoom account. You'll see it on the lower bar there. If you click Q&A, you can simply type in a question and I will be able to sort of see what comes through. We have a lot of participants today. We had over 230 registrants for this webinar, so obviously a hot topic. And so we think that will be the easiest way to sort of manage the Q&A. If you would just please utilize that feature, type your questions in and I will ask them of Micah at the appropriate time. So with that, I'll go ahead and turn it over to Micah. Micah, if you will, please proceed. Thank you so much for being here.
Okay, great. Thanks very much. I'm going to go ahead and share my screen here. So hopefully that's visible now. And Brian, you can see that?
Yes.
Okay, fantastic. So again, thanks very much. Really appreciate the opportunity to visit with you all and the introduction from Brian. Obviously today we're going to be talking about insurance coverage for the significant losses that so many companies have experienced in connection with the current pandemic. And certainly among all of the companies that have been affected, hotel owners are certainly foremost as far as those who have lost revenue because of what's going on in the world right now. It's a little difficult to put a precise figure on what's happening, but according to one estimate, this is from the American Property and Casualty Association, between $255 and $431 billion per month have been lost as a result of the pandemic in terms of revenues. And again, certainly hotel owners are among those that have been hit the hardest. So what I want to do today is talk a little bit about what's happening with those losses. Are people able to recover those losses from their insurance carriers? Many of you have in your files, you have insurance policies. You spent a lot of money in premium on these policies over the years, and in particular in recent years, premiums have gone up. And so the question is, are those assets now valuable to you? Do they have value in the context of this pandemic? And so I want to talk about, just as a broad overview, several things today. We'll talk about one of the key requirements under these policies to have physical loss or damage and how insurance carriers are addressing that particular issue in the policies. We'll talk about a virus exclusion if you happen to have that in your policy. We'll talk about some of the other sublimited coverages that exist in your insurance for civil authority, ingress, egress. We'll talk about practical things you can do in pursuing your claim. And then we'll talk a little bit about alternative coverages that you might have that you want to pursue. And then finally, as now businesses in many parts of the country are starting to open back up to re-engage with employees and with customers, how do you deal with potential liability claims, and is there coverage for what you might expect on that front? So the first item I want to talk about is this issue of physical loss and damage, because this most commercial property policies will be unique in terms of what is there. The terms are going to be different from one policy to the other. But what will be common to all of the policies is this requirement to have some kind of physical loss or damage. And really that begs the question, this is sort of the front line of the disputes that we're seeing with insurance carriers. What does that mean to have, or to need to have physical loss or damage to sustain a claim? And when we look at what those terms are not defined in the policies. And so when we look to how courts have interpreted that language, we have a little bit of guidance. This is one example of a definition from the Fifth Circuit. And the language is, in order to have physical loss or damage, you need to have a change from a satisfactory state to an unsatisfactory state. Now that's not all that helpful really when you think about it, because obviously the carriers will say you haven't met that threshold. At least that's what we're seeing in claims. And so what you really have is a spectrum of perspectives on what constitutes physical loss or damage. On one end of the spectrum, obviously if your property is actually physically injured, then you can demonstrate physical loss or damage. On the other hand, at the other end of the spectrum, if you're just talking about economic loss, if there's a recession and your business slows down, that likely wouldn't constitute physical loss. And so somewhere in the middle of those two extremes, we have this idea of loss of use. What if you cannot use your property for the purpose that it was intended and your business as a result suffers? Does that loss of use constitute a physical loss or damage for purposes of this insurance coverage? And fortunately, we have a lot of case law out there that answers that question. There are cases from all over the country that stand for the general proposition that you don't have to have actual damage, injury to your property to qualify for physical loss. Here's an example. The Hardinger case. This is from the Third Circuit in the Northeast. In this case, you had a home that was, the water was fed by a well. The well actually had Ebola contamination, and as a result of that, the home was uninhabitable. In that case, there was a summary judgment motion filed by the insurance carrier. The court said whether there was physical loss or not, in that context, constituted a fact issue. And so the court was unwilling, as a matter of law, to say that there was not physical loss or damage. Other cases are more distinct and affirmative in saying that physical loss does not require damage. There are lots of cases in the products liability context. One case I'll highlight here from West Virginia, this is the Murray case. Here you had a home that was near a landslide, and the home itself was undamaged, physically unharmed. But because of the threat, the imminent possibility that the home could be destroyed and someone could be injured, that home was unusable. And the loss of use was what the court in that case found constituted physical loss that was covered by the policy. Lots of other examples. There are just a few here that are highlighted. One from Texas, but again, there is a body of case law out there that policyholders can rely upon for the argument that your property doesn't need to be damaged in order to qualify for that threshold physical loss or damage in the coverage grant. So of course, carriers are going to say, well, those cases don't deal with a pandemic, they are distinguishable, and that's really where the fight is going to be and already is. There are cases that have already been filed around the country. There has been a motion by one of the plaintiff's lawyers in Illinois to establish a multi-district litigation panel that would handle these cases from around the country on a consolidated basis to make sure that decisions were made consistently. That hasn't been ruled upon yet, but really where we see the conflict or these disputes shaping up is over whether the existing case law on physical loss or damage really applies in this situation. So where we're looking and where we're focusing our analysis on is on analogous situations where we could say, this is how courts in the past have dealt with this, and this is how it should be dealt with now. Unfortunately, we have one set of examples in the context of Hurricane Katrina back in 2005. If you look back then, there was a situation where property and goods in the New Orleans area were almost presumptively tainted because of the hurricane. Even properties that were not damaged, goods that were not damaged, were seen or perceived to have less value because of the possibility that those goods and properties had been impacted by the hurricane. And back then in 2005, they called that the Katrina effect, as far as what the hurricane did for property in Louisiana. Now, what we're seeing is very similar. We have what's called the Corona effect. Properties that are not actually damaged, but the perception by the public is that somehow they're unsafe, or that you might end up getting sick if you go there. And as a result of that, properties have lost money. They've lost revenue and customers and business. And that Corona effect, which courts in the past, in the Katrina context, found constituted a physical loss. The result should be the same here, that the public perception of a property being unsafe or unusable constitutes a physical loss for purposes of this coverage. What we're also seeing in terms of arguments from the carriers is that in order for there to be physical loss, you have to have something, a condition internal to the property, not some external cause affecting the property, but something on the premises. Now think about that. What that means is if you take that argument to its logical conclusion, if you had a government authority build a wall, surrounded your property with a wall, soldiers, completely restricting anyone from going in or out, according to the carrier's view of the world, that would not constitute physical loss because it's external to the property. Obviously, that doesn't make any sense. It's a physical barrier. If there is something physical that prevents someone from accessing your property, no doubt about it, you've experienced a physical loss. So the same result should apply here. The idea that an internal cause is necessary to sustain physical loss just doesn't, frankly, make sense. So what is it? What are we saying is the physical loss that most hotels have experienced in the context of the pandemic? Obviously, if you can't use your structure, if you have physical hotel rooms that are not being used, have lost their functionality because of stay-at-home orders, shelter-in-place orders, lockdown orders, you would say that constitutes a physical loss. What else? If you've lost employees who cannot or will not come in because of fear of sickness, or they have become sick, that's a physical loss. Loss of supplies. I mean, think about it. If homeowners can't buy toilet paper, how can a hotel business be expected to operate and have the supplies that it needs to continue operations if your business has lost suppliers or materials needed to operate? That's a physical loss for purpose of your policy. Last but not least, the most important loss, obviously physically, is the loss of the customer, the patron. If you have physically lost the customer base that you need to operate your business, that's a physical loss, we would say, for purposes of your insurance coverage. To draw another analogy, some of you may remember this image from Hurricane Ike back in 2008. This was a home on the Gulf Coast that miraculously was unscathed by the hurricane when everything else around it was completely obliterated. And so ask yourself the question, has this house, which is physically unscathed, has it sustained a physical loss when everything around it has been devastated? The idea, the point is that our properties are not, they don't exist in a vacuum. They are connected to their environment. If the environment around our assets, the insured property, has changed, if everything around it has been devastated, that property has absolutely sustained a physical loss. And you see that's what's happening to hotel owners. The environment to which properties, insured properties, are connected has changed. That is a physical loss for purposes of insurance coverage. One more example just to illustrate the point a little further. Back in 1958, a physicist by the name of Samuel Cohen invented the neutron bomb. This was an innovation in nuclear physics because the idea behind this bomb was it was supposed to be a tactical weapon. Instead of channeling all of the energy from the nuclear reaction into an explosion that would destroy property, the idea was that it would channel that energy into radiation that would cause loss of life, but minimize the loss of property. So theoretically, you would have an explosion that would keep some buildings intact while devastating anything living within that area. So you have a building that's intact, but you have loss of life all around. That's obviously the situation that we are experiencing now. So imagine in that context, imagine an insurance carrier telling someone whose property had been affected by a neutron bomb that because the structure was unscathed, that there is no physical loss or damage for purposes of coverage. Obviously, that's absurd when there is loss of life, physical loss all around it. That's the situation that we have here, and certainly representing policyholders on these claims, we feel very strongly that the loss that we're talking about when we talk about hotels who cannot operate because of the pandemic, that qualifies as a physical loss.
Micah, if I might just jump in for a moment before
Sure.
we move on to virus exclusions. We received a question in the Q&A box I'd like to pose to you if you don't mind.
Absolutely.
The question is, the asking basically the cases that you had highlighted maybe even a few slides ago are mostly with regard to residential homes. And the questioner is curious to know if there are any prior examples of business properties, cases that have been won in terms of physical loss or damage instead of just residential type facilities.
There are examples. Most of the commercial cases, non-residential cases that involve this kind of issue where a court has said, we find that there is physical loss in the absence of damage. Quite honestly, most of them deal with products where we have commercial products that cannot be used because of some taint, some perception, even though they're physically unharmed. I'm trying to think now if there is an actual property of a building, a structure, where that's been the case. I can certainly look into that and follow up and send some more information later, but I think my memory is that most of the cases where we're talking about this issue in a commercial context, we're talking about a product. There may be some cases in the commercial context where you have, I remember in fact there was a school, there were some business cases where you had some kind of contamination like asbestos, where again, the structure was unscathed, but because of the contamination, the building could not be used, and that was found to be a physical loss. So there are some cases in the commercial context as well.
Thank you.
Sure. Okay, so switching gears and talking about the virus exclusion. Assuming that you get past the hurdle of showing that there is physical loss or damage, we see this already. If there are other exclusions that the insurance carriers will rely upon, one of them is the virus exclusion. In 2006, this was after the avian flu pandemic, the Insurance Services Office, this is sort of a trade organization that promulgates insurance forms, they came out with a virus exclusion that has been added to some, certainly not all, commercial property policies since 2006. And that language is here. It applies to loss or damage caused by or resulting from any virus. And it includes bacteria, other microorganisms that cause disease or distress. So the reason that the causal language, the resulting from or caused by language is highlighted is because that language varies between policies. Some policies will have that language, some policies will use the relating to preamble, some will say it applies to virus, whether the damage is caused directly or indirectly. Other policies are more expansive, that include what we call the anti-concurrent causation language that says, in effect, if a virus is the cause of your loss, it's excluded whether the cause was direct or indirect, or regardless of any other cause that may have contributed or any sequence of causation, it's excluded. There are other exclusions as well that deal with communicable disease, microbes, and frankly, most policies have a pollution exclusion. And for policyholders that don't have an express virus exclusion, we see that carriers are taking the position that if you have a pollution exclusion that applies to contaminants or irritants, carriers are saying the virus qualifies as a pollutant under a pollution exclusion. So the question then is, well, what if I have a virus exclusion or a pollution exclusion? Is my coverage barred? And the answer to that is, think about this for a minute. Viruses cause sickness. They make people ill. They're disease agents. Viruses don't, in the ordinary course of events, cause loss of income. Right now, regardless of how well you clean your property, there are probably other viruses present at some point. Those viruses that happen all the time don't cause a loss of income. What's causing the loss of income in this scenario is not even the coronavirus. It's how people are reacting to the coronavirus. The fact that our healthcare system is not equipped to deal with a large pandemic, the fact that we have people justifiably concerned about mortality rates and about how this disease is transmitted, that public reaction, which we're seeing in the form of lockdown orders, stay-at-home orders, that is the proximate cause of people losing income, not the virus. So if you have a virus exclusion that requires that the virus or the loss be caused by or result from proximately the virus, then there's an argument to be made that that exclusion doesn't apply because the virus is not the cause. It's the public reaction to the virus. If you have a pollution exclusion, again, most of your policies will have a pollution exclusion. The fact that the ISO organization promulgated a specific virus exclusion in 2006 begs the question. The pollution exclusion has been around forever. If you have a pollution exclusion that already applies to viruses, why would you need a virus exclusion? Some of you have policies that will have a virus exclusion and a pollution exclusion. One of the cardinal rules of contract interpretation is that you can't read policies to be incongruent internally. They have to read and make sense internally. If you adopt an interpretation that would render one part of the policy meaningless, you can't accept that interpretation. So to say that a pollution exclusion that refers to contaminants and irritants includes a virus would render the virus exclusion completely meaningless. So again, these are some of the arguments that we see playing out in the context of these kinds of claims. And so even if you have a virus exclusion, if you have a pollution exclusion, think about that carefully, look at it carefully, because not every virus exclusion, and certainly pollution exclusions in the abstract, should not apply in this context. So again, want to switch gears and talk about what about other coverages. Some of you may have heard about civil authority coverage, ingress, egress. These are certainly sublimited coverages that you would think of in this context, given the lockdown orders that we have in most jurisdictions. So civil authority coverage is going to apply, and this is, every policy is going to be a little bit different, but generically, civil authority coverage applies to loss that results from the suspension of your operations caused by the order of a civil authority that prohibits access to your property. And certainly that's what we're seeing in this situation, where you have counties and states and local authorities ordering people to stay home, ordering non-essential businesses to stop operating. That's a prohibition on access to your property. The next step in the analysis is these policies will require, most of them, that the civil authority order be the result of direct physical loss or damage to some other property within some distance of the insured premises. So that begs the question, do we have, or the orders that we're talking about for civil authority orders in the pandemic, do they meet that condition? So if we talk about what's the physical loss or damage that the civil authorities are responding to in issuing these lockdown orders, in some cases it's actual virus exposure. In other cases, these orders are being issued in anticipation of loss of income. And to use as an example, let's look at the Dallas County order from March of this year. This is the order, the revised order that said, again, everybody's got to stay home. Non-essential businesses have to stop operating. The recitals to that order make very clear. In fact, it says the COVID-19 virus causes property loss or damage due to its ability to attach to surfaces for prolonged periods of time. So that by itself, if you can demonstrate, certainly in large markets where you have large population centers, what this means is that if you can demonstrate that you're in a hotspot, or if you're in an area where you would see, or you can document, and frankly, there are apps, there are computer applications, but what it would really mean is having an expert demonstrate that there is some kind of exposure to the coronavirus within the defined radius around your property. If you can demonstrate that, then you have an order that is issued, certainly in Dallas, and we see this in other markets as well. New York, New Orleans, Houston, Florida, large markets will have similar language that acknowledges that the virus causes property loss and damage. So again, if the policy requires the order to be the result of physical loss or damage within a distance of your property, then these kinds of orders that acknowledge the effect of the virus on property would meet that condition. The other item is, well, what about economic loss? Some of these orders are more explicit than others. The Dallas County order is a little ambiguous in its reference to protecting health and welfare of the public. Other orders are more explicit in finding that the reason for the order is to mitigate the possible loss of income to businesses if the pandemic were to get out of control and be sustained for an even longer period of time. So again, the upshot of all this is that this will require expert testimony, but experts who can demonstrate that these civil authority orders are the result of physical loss or damage proximate to your property, or loss of income, loss of use proximate to your property. That testimony, that kind of evidence would satisfy the conditions in these civil authority clauses. What about ingress egress? This is very similar in terms to the civil authority coverage. The only difference is that the condition is that the property has to lose the ability to go in or come out based on physical loss or damage to some property adjacent to or within another radius of the insured premises. The thing about the civil authority and the ingress egress coverages is these are called sublimited coverages, which means typically your commercial property policy will have a broad overriding business income limit that will usually be substantial. The civil authority coverage, the ingress egress coverage by comparison, is usually a much lower limit. Sometimes it's a dollar amount, sometimes it's a limit that is expressed in days. 30 days, 60 days is pretty common for what we're seeing. So that begs the question, why would you go through the process of establishing that you qualify for civil authority coverage or for ingress egress coverage if that coverage is less than what your general business income coverage would be? The answer to that is, if you look at the business income coverage, the other terms that apply or that define what that coverage is include a period of liability. And this is the way the insurance carriers express how long are we going to grant your claim for lost income. the way most policies, and this is not all, most policies will define the period of liability as the period that starts when you have physical loss or damage and ends when the property is repaired or replaced. Now, obviously, no one is repairing or replacing property in this context. So you would expect the insurance carriers to say, well, that's proof that your policy doesn't apply, that your business income loss doesn't apply, because this period of liability requires the repair or replacement of property, which is not happening. The answer to that is that most policies also include an extended period of liability that begins when the property is repaired or replaced and ends when business is restored to the condition that existed before the loss or damage occurred. So in this context, because no one's repairing or replacing property, the primary period of liability is 0. But the extended period of liability, which depending on your policy could be several months, it could be as much as a year, is what would be the relevant period in defining how long does it take for your business to get back to a normal position. So we talked a lot about terms and conditions and what the coverage looks like and where the disputes are. What does that mean for you practically as a hotel owner? Here are a couple points to consider. Number one, many of you have probably already heard this, but the insurance carriers have been very active in promoting what I'm calling the no coverage narrative. They have been very pessimistic about coverage. They've said there is no coverage because there is no physical loss. And frankly, brokers have been sponsoring that kind of narrative as well. And some of you may have heard that. What I've just explained to you in terms of what the actual issues are and the fact that there are good arguments and supporting case law to make the point that there is physical loss or damage. There are arguments and case law to support the point that if you have a virus or pollution exclusion, that those exclusions should not apply. So the first point I'll share with you is don't subscribe to the no coverage narrative. Look at your policy. If you need to, talk to your broker, talk to someone else about whether you have a potential claim or not. But don't simply assume that this asset that you've paid a substantial amount of premium for is not going to provide any value in this current crisis. The second point is give notice. Don't sit on your rights. Don't delay in giving notice of your claim. At a minimum, at least put your foot in the door, because frankly, there are so many claims and the capacity of the insurance claims apparatus to handle them all is limited. The sooner that you can get your claim noticed, the sooner you get your place in line, so to speak, in terms of getting that claim handled. So you don't obviously want to get caught in a backlog of claims. Give notice now. There's no downside in doing that. Some of you will say, well, what about my premiums? How is it going to affect a premium going forward? If I give notice now, is that going to affect my renewal? Quite honestly, given the circumstances that we're in right now, the market is already pricing this pandemic, regardless of whether you give notice or not. So go ahead and give notice. Be careful about how you give notice. It's very common, very easy to sort of use as a shorthand the coronavirus or COVID-19 or the pandemic. Be careful about that, because if you have a virus exclusion, if you have a pollution exclusion, you don't want to automatically link your claim to the coronavirus or to COVID-19. Talk about your claim in terms of the pandemic, talk about it in terms of a public health crisis, but be circumspect, be deliberate in terms of how you define your notice, so that you're not giving the carrier something they could use to deny your claim. What we're seeing once notice is given is that most carriers are generally, and this is going to vary by situation, most carriers are very aggressive and invasive in terms of what information they're asking for. Many of them will want to have interviews. Some of those interviews may be recorded. Again, use caution in how you're responding to requests. If you're going to have an interview, find out if it's going to be recorded. And if at the end of the day, this is going to require a little bit of thinking about your strategy for your claim, but think about whether it makes sense to have a frank discussion with your broker at the outset, or excuse me, with the insurance carrier at the outset. If you know you're going to have a fundamental disagreement with your carrier over the existence of physical loss or damage, do you really need to go through the machinations of doing interviews, gathering documents, even putting together a proof of loss? Find out ahead of time. Obviously, if you think this is a claim that really has merit, you don't want to not satisfy a condition. Make sure you are timely and responding to requests and cooperate. But again, be careful about the information you're providing to make sure that it's not going to be used against you in a denial. Look at the deadline for your proof of loss if you need more time, especially given the fact that many people are still experiencing losses that are ongoing. Ask for an extension of time so that you have the time you need to comply with those policy conditions.
Micah, if I might just jump in there briefly, we've got a couple
Sure.
of questions that have come through.
Sure.
So the first question is, what form of notice should we give our insurance provider? And I think what the questioner is getting at there is, should we be calling them, sending them an email, sending them a letter through the regular mail system? How do we go about that?
It's going to depend. I mean, most policies are not very specific about the kind of notice that you are supposed to provide, but make sure you check, talk to your broker. That's honestly why you have a broker, is to help with this kind of thing. And using your broker to give notice will usually be the most efficient way to get it done. But the practical answer is, you want it to be in writing. You want to have a record of it. So just over the phone is probably not the right way to do it. But an email, a letter, something that, again, a record that shows you've put the carrier on notice is going to be sufficient.
Okay, and the same person is asking, is there a template or a best way that they should provide that notice? Is there any method, if you will, to the verbiage you should use?
Again, it's going to depend to some extent on, this is going to be a typical lawyer answer, it depends. But really what you want to do is think about your claim. Think about the strategy. Are you going to approach this from the standpoint of, is the main issue you're going to fight about physical loss or damage? Is the main issue you're going to fight about a virus exclusion? So think about your claims, sort of the long view of your strategy. What are you trying to accomplish? What are you anticipating the issues are? Clearly, physical loss is going to be an issue. So crafting your notice in terms of physical loss, identifying the claim in those terms by saying, I've sustained physical loss at my property at this point in time or these dates. That's one way to approach it, but ultimately you'll want to be both customized and careful about how you describe your loss. And it's going to depend on your policy and on how you want to, what your strategy is in terms of getting the claim ultimately paid.
And to pick up right there, Micah, I think it's probably fair to say that this is really why it's so important that you align yourselves with an expert to help you navigate this process. While you were giving that answer, Micah, we had multiple other questions come through the Q&A feature asking about, hey, I've actually already given notice to my insurance company. They've already denied me. Is now a good time to solicit the help of a lawyer to navigate it from here?
Yes, don't get me wrong. We certainly want to help as many people as we can, but it's going to be a sort of a case-by-case basis. But if you've gotten a denial already, certainly you'd want to look at that denial and see, does it merit a response? And again, there's some strategy that goes along with this, because on the one hand, most of the time, at least our experience has been just sending a letter back to an insurance carrier after they've denied, almost no matter how well or how well supported those arguments are, it's unlikely the insurance carrier is voluntarily going to say, well, thank you for your response. I'm going to change my position now and grant you coverage. That just, it frankly doesn't happen. But query whether from an evidentiary standpoint, if you think this is a claim that has enough value that you're willing to pursue litigation over it. Do you want to create an evidentiary record, something that the jury might see later that will show that the insured disputed this, the policyholder did not accept the denial and pushed back and raised good arguments that the carrier simply ignored? So again, it's going to be sort of a case-by-case determination about what your strategy is and how where you think this is going. But certainly if you think you have a claim that has been denied unfairly and that there are ongoing losses that are substantial that would merit investing in legal advice, then that may be the right approach.
Okay, thank you, Micah. We got another question regarding a hotel owner who actually has kind of a boutique type property, a specialized type of property, if you will. And they've had difficulty finding insurance providers over the years in terms of the uniqueness of their operation and how to get proper coverage for it. And she's asking that if they make a claim, will they be at risk for potentially losing their policy moving forward?
There is always that risk. I mean, frankly, let me put it in context here. Especially in the world we live in, there's almost nothing that is without risk entirely. But if you look at the overall spectrum, just giving notice of a claim is probably not going to mean that the insurance carrier will withdraw or non-renew your coverage. That being said, I mean, honestly, given the situation that we're in right now, the fact that insurance carriers are inundated with these claims and no one really knows, at some point there's going to be a judicial decision that sheds some light on these issues. And depending on where that decision is made and how well reasoned it is, it's either going to have a big effect on the pipeline of claims out there or it's not. But all that to say, regardless of that outcome in the near term, the insurance markets are sort of upside down right now about this pandemic. And so even before the pandemic, the last 2 years, we've had what's called a hard market on property, on D&O, on a lot of different coverage lines, where you see premiums going up, terms getting more restrictive, and even some carriers exiting the market. So I can't tell you that by giving notice, you're not going to get a non-renewal notice or your carrier's not going to exit the market. But quite honestly, I wouldn't expect that simply giving notice is going to cause that. There are larger, even capital market level issues and factors that are in play here as far as how insurance is getting underwritten. So that's maybe not a satisfying answer, but I think the risk of giving notice is very small, but frankly, the markets are in upheaval right now.
Micah, we received an interesting question here, something you and I have actually discussed a little bit offline. And the question is with regard to class action litigation. So this particular owner says they have already been denied, but since have received an invitation to enter into a class action lawsuit. And in this specific case, it would be on a contingency basis for the law firm representing the class. Can you just comment on the advantages or disadvantages of entering such litigation?
Sure, and I can only speak obviously in generalities here because there are individualized factors as well, but on a very global basis, there are a couple reasons why you might consider a consolidated claim, whether it's a class action or some other grouping of policyholders. One is obviously to share costs, to spread the burden of litigation. The other is if you happen to be litigating against the same carrier, then there is potential leverage or you get an aggregated claim is worth more. Maybe the insurance carrier pays more attention, is willing to negotiate more than you would if you were on your own. On the other hand, if the insurance carriers are not the same, that leverage, that multiplier factor really isn't there. And frankly, the risk is that because these policies are unique, you would expect that in a class action context, and frankly, I haven't even talked about the ability to certify a class requires that there be common issues between the policyholders, and from a damages standpoint and from a factual standpoint, that may be very hard to sustain. But the risk is that if there are differences in the policy terms from one plaintiff to the other, you can expect that the insurance carriers will try to exploit those differences and play policyholders off against each other. That may not always happen, and if you can get a consolidated claim that has the same terms and that you can avoid that kind of risk, that may make sense, but there is certainly risk in policies that are not the same.
Great, thank you. I believe that's all the questions we have at the moment, so feel free to proceed.
Okay. All right, so switching gears now to talk about some specialized coverages. This is outside of this is not your standalone commercial property policy. An event cancellation policy is usually a standalone form that you would buy if you had a really significant event coming up and you want to make sure that if it doesn't come off, you've got some coverage. These policies, again, will vary by terms, but it's usually limited to specific events, usually requires that the cause of the loss be outside of the insured's control. So if you're canceling voluntarily, that's potentially an issue. And then finally, the language in most of these forms will require that there be losses arising out of cancellation, interruption, postponement, or of a specified insured event. So again, these policies are a little bit unique. They're not that common, but certainly if you have this kind of coverage, and if your event didn't come off because of the pandemic, you certainly want to pursue that and make sure that the value in that policy is not ignored. Other kinds of specialized coverage, we have communicable disease coverage. This can either be a standalone policy or part of an endorsement to your commercial property policy. This kind of coverage, I mean, most of you will not have actual contamination at your premises, but if you do, if you have an actual confirmed case, some kind of contamination, this is what this would apply to. So you have to have the actual presence of a disease. You have to have an order in most policies, either from a civil authority or from one of the insured's officers in response to that actual presence. And then if you have sort of those elements, you can recover, depending on terms, you could recover the cost of cleaning up the actual contamination. You can recover the loss of income during that period of time when the cleanup was going on, and potentially some public relations expense as well. So again, these are more focused. You won't have the same limits and certainly the same amount of coverage that you might under your commercial property policy, but certainly if you have actual contamination and those conditions satisfied, you'd want to follow up and take advantage of that kind of coverage. So the last issue I wanted to just raise, and this is obviously more current as things are starting to emerge from a lockdown state to a partial opening in some places. Now that you have customers coming back, you have employees back at non-essential businesses, is there risk of a potential claim, and will that kind of risk be addressed by insurance? So the kinds of claims we're talking about are employees and third parties from a premises liability standpoint. So commercial property, your CGL coverage would be the policy you would look to for third-party claims for bodily injury. And your CGL policy, that's what it's for. So if someone gets sick and makes a claim, you would look to your CGL policy. If an employee who would not be covered by your CGL policy but would be under your workers' comp employer's liability policy. If that circumstance occurs, again, look to your workers' comp policy. There are other potential liability issues if, and this is just obviously potential, but as employees are coming back, there are questions about if you're in a high-risk group, will that employee be retained or let go? There are potential discrimination claims. There are employment practices claims that are implicated by not only how people have been terminated or maybe furloughed during this period of time, but also on the rehiring side. We're sort of in a different environment now where health is going to play a role in hiring decisions. And if that's the case, are there going to be claims? You would look to your employment practices liability policy, which is going to be either a standalone policy or part of your D&O policy for most companies. That's where you would look. So what about potential insurance issues? Here are just a couple that we're seeing or considering at this point. One is, again, pollution exclusions. We're seeing carriers that are looking at these exclusions and saying, even if there's no express reference to a virus, if it does reference, and most of them will, a contaminant or irritant, is that sufficient to trigger an exclusion for purposes of your CGL coverage? Another issue is the number of occurrences. This is important because ultimately your limits, and in some cases the deductible or self-insured retention that you would pay, is going to depend on the number of occurrences. So if multiple employees, multiple customers get sick, is that one occurrence? Is that more than one occurrence? The analysis typically is you look at the cause of the number of causes to determine the number of occurrences for purposes of liability claims. So just be careful about how you describe causation, about how you describe the number of occurrences in the event of a claim, because that again could have an impact on your limits or on your number of deductibles. The final issue is a little bit of a complicated one, but I want to highlight it because what we're seeing for a lot of you, renewals have already happened. Some of them you're in the middle of right now. Some will happen later on in the year. But what we're already seeing is that in response to the pandemic, insurers are including new terms that purport to exclude liability or other coverage. This applies to property too, for pandemics, epidemics, diseases of the variety that we're seeing right now. So that begs the question from a liability standpoint, if you expect that your coverage going forward is going to be limited in that way, is there a way to preserve coverage under a current policy that does not have that kind of limitation? And the way that some of these liability policies work, and this is your D&O, your claims made policies, they have what's called a notice of circumstances feature that says if you give notice of a condition that is expected to give rise to a claim in the future, even though there is no current claim now under this policy, and there is a future claim in some other period that arises out of the conditions that you gave notice of today, that future claim will be deemed to have been made at the time you gave the notice of circumstances under that earlier policy. This is definitely an issue that will require thought and analysis and consultation with your broker and others to figure out if this is the right strategy for you. But consider whether it makes sense to give notice of circumstances under a claims made policy now, so that if your future claims made policy is more restrictive, you have preserved potential claims under that earlier form, if that makes sense. So again, we could probably talk a lot more about that, but our time is short. I hope this has been helpful. I know there are so many companies out there that have sustained real significant loss. I hope that those of you who have those losses can take the time to consider your policies and see if there isn't some way to address those losses, mitigate them from the insurance assets that you currently have. So with that, I know we've already addressed some questions, but certainly happy to answer any others that have come up.
Thank you so much, Micah. And over the last couple of minutes, we've had a few questions come through. In fact, I'm going to go ahead and handle two of them at once because they're really on the same issue. So we have a couple of our members who are asking about releases and whether or not, as a hotel operator, you should actually have guests sign a waiver releasing the property from liability associated with the coronavirus. This is a question we fielded, of course, at the association over the last several weeks, but definitely interested to hear your thoughts on whether or not hoteliers really should consider having any type of waiver signed by registered guests.
Honestly, that is a question I really haven't had a chance to consider or reflect on. I can certainly see obviously from the liability standpoint, some reasons why you would want to do that. Certainly from the business end, some reasons why you might not want to do that. What I feel like I can say without having had a chance to really consider that question carefully is that it shouldn't have an impact on your insurance coverage, your liability coverage, if you don't. So in other words, by not having a release, you should not be, that shouldn't penalize you in the event that there is a claim and you end up going to your liability carrier. Your liability carrier should not and would not be entitled to say, because you didn't get a waiver, we're not going to cover this claim. So I'll certainly reflect on the broader question, but at least I can answer that component as it relates to your liability coverage.
Thank you. And I'll tell you, basically our advice for those of you who are here this morning, our advice has generally been to consider both the pros and cons of doing this. Because on one hand, we think there are some, it's kind of unlikely that you'd be able to shield yourselves from any and all potential liability associated with coronavirus related claims, just because you have a particular term on the registration card that a guest signs saying that, you know, they waive the right to sue the hotel essentially based upon a COVID claim. At the same time, you know, depending upon the way you craft that release, you can at least apprise your customers that, you know, you have followed, you know, certain enhanced cleaning protocols, you know, whatever it is at your particular property, whether it's adherence to the safe stay standards that have been promulgated nationally across many brands, or some other enhanced procedures, you can give guests notice of that. And then you can basically include, you know, the guest agrees they would waive liability. But at the same time, I think you have to consider what are the public relations type of concerns with doing so. I mean, if you're having guests sign that, you know, consistently every time someone's checking in, what type of business reputation issues arise with regard to asking every registered guest to do so. So I think it's really not a one-size-fits-all answer, and it does depend upon, of course, the nature of your property, where you're at with cleaning protocols and the general customer base that you serve. But I guess all that to say, if you have specific questions about your particular hotel, if you're trying to craft something along these lines, please feel free to reach out to THLA. We'd be happy to walk through that with you, of course, as a member service. Micah, we got a couple other questions here, and let's see. The first one is regarding the Dallas County order that you gave as an example earlier in the presentation. Mm-hmm. The person is asking if there are any, to your knowledge, class action type of suits that have been formed or are being formed regarding Dallas specifically.
I know there have been some Dallas-based properties that have filed lawsuits. I'm not aware of any class actions per se at this point. I mean, that's not to say that there isn't somewhere some class member who is, you know, a Dallas business. But I mean, we try to follow this a little bit carefully, and it's getting to the point now where there are so many filings, it's a little bit difficult to keep track of. But I do recall in the media seeing recently some, I mean, for example, I think it was there was a Dallas hotel that filed suit recently in Chicago. It was not a class action. But again, I'm not specifically aware of any Dallas-based class groups.
And then the final question that I'm seeing in our Q&A box here is actually very pointed to you, Micah, specifically. And I think I'll go ahead and answer it because it's about a potential client arrangement that you would have with a hotelier anywhere in Texas. They're basically asking about how that fee structure works. Let me just answer that real quickly and say that, you know, like I mentioned at the outset of the call, Micah has been a trusted colleague and friend of THLA for several years. It makes a lot of sense that we would bring him to the table to present on these issues to you all for all of the members. So to the extent that you are interested to communicate with Micah offline privately regarding your particular matter, I know that he's going to include his contact information. In fact, Micah, you could go ahead and skip to that slide. His contact information is there with his direct number and email address. You are happy to reach out to him individually to talk about those particular items and a possible claim if that's something you're interested in. So regarding the question that was asked, please feel free to contact Micah individually, and I know that he would be happy to help you. Again, he is a friend of the industry and has represented hoteliers in many other matters. So it's certainly a familiar face and someone we're happy to put forward before the members.
Thanks, Brian. I appreciate that.
Of course. Okay, well, I think we're 2 minutes over time, so I think we'll go ahead and call it a day for now. Let me just tell you all that we are recording this webinar, and this is something that we will be emailing a link to you all to be able to access moving forward if you want to review any of the material, if you'd like to listen to the entire thing again just to get your hands around the subject matter. Whatever you'd like to do with it, we are going to make it available to you all, so please be on the lookout for that email correspondence. We're also going to include some material about the webinar and a link to the recording in our upcoming newsletter that is set to go out at the end of this month in just a few days. So you will see it multiple places. Thank you so much for tuning in. We had a great response, 230 registrants for this webinar, so obviously very much in demand topic. Micah Skidmore, thank you so much. Thank you for the value you've brought to our members today, and we certainly look forward to our partnership continuing forward.
Great. Thanks again, Brian. Really appreciate it.
All right, everyone. Take care. Bye-bye.